Hello guys, I am Muhammad Shafiqul Islam Rajuan. Today I want to discuss a subject. The subject is of law, and today's subject is the Evidence Law, Evidence Act 1872. The Evidence Act is a procedural and an executive law. It was passed on the 15th March in 1872. It came into force on the first day of September in 1872. It has 167 sections. In the Evidence Act, there are 11 chapters, 1 to 11, such as Chapter 1. Chapter 1 is of 4 sections from 1 to 4. Chapter 2 is of 51 sections from the section 5 to 55. Chapter 3 each has 3 sections from 56 to 58. Chapter 4 is of 2 sections from 56 to 60. Chapter 5 it has 29 sections from the section 61 to 90. Chapter 6 is of 9 sections from the section 91 to 100 section. Chapter 7 is of 13 sections from the section 101 to 114. And chapter 8 has 3 sections from 115 to 117 section. Chapter 9 is of 17 sections from the section 118 to 137 section. In chapter 10 there are 31 sections. It has started from the section 135 to 166. Chapter 11. In chapter 11, there is only 1 section, that is 167 section. You know that there are 3 parts in the Evidence Act. Part 1 and Part 2, Part 3. Part 1. Part 1 has started from the section 1 and has ended at the section 55. In total, section number 55 section. And these 55 sections are described in 2 chapters, 1 and 2. Part 2 has started from the section 56 to the section 100. In total 45 sections. It has included 4 chapters, chapter 3 and chapter 6, chapter 3 to chapter 6. Now I want to discuss part 3. Part 3 has started from the section 101 and has ended at the section 167. In total section are 66 that are described in 5 chapters from the chapter 7 to 11. Now I want to discuss the section part by part, one after another. My dear guys, just I have been benefited by this work of presentation, and if you want to just hear my presentation, I think you must be benefited. Of course, you must be benefited. So just I want to mention you the section chapter by chapter, one by one. Just you read out with me, either silently or loudly. Okay, thank you very much. Come to the point. Section 1. Section 1 just discuss the short title. And section 2, a repeat of enactment. Section 3 discuss about the interpretation clause. Section 4 discusses about 3 points: may presume, shall presume, and conclusive proof. I think may presume. This is the opinion of the of this act. In some section, you must presumption. You must presume, may presume, and this is decided by this act. And in subsection, you must presume, shall presume. You must presume, shall presume. And in some other section, you must presume conclusive proof. And there are 3 words. At first, may presume. These are provided by the act, and shall presume. Just you have to utter such type of matter that has been directed by the act. And in conclusive proof, that is declared by this act. Okay, come to the point. Come to the discussion of the section. Section 5 and section 5 to 55. In this section, the summary of this section and the title of this section shall be the relevance of fact. Of course, relevance of fact just is facts are described by the following section. Okay, section 5 discuss about the evidence may be given of fact in issue and relevant fact. Section 6, relevancy of fact, that is forming a part of a same transaction. You have to remember that relevancy of fact, that is forming a part of same transaction. Section 7, facts which are the occasion, cause, or effect of fact in issue. Section 8 discuss about the matter, motives, preparation, and previous or subsequent conduct. What is the matter? Subsequent conduct that are relevant. Section 9, the facts that are necessary to explain or that are necessary to introduce the relevant facts. Section 10, the things that are said or done by the conspirator in reference to common design. As the common intention, common design. same as common intention. Common intention is the section of 34 of Penal Code, and the common design is of the section 10 of the Evidence Act. Section 11. When facts are otherwise relevant, become relevant. Section 12. In the suit of damages, the fact that tending to enable the court to determine the amount are relevant. Section 13. Section 13 discusses about the facts are relevant when the rider custom is in questions. Section 14. The fact that showing existence of mind, existence of the state of mind, existence of the state of body, existence of the state of bodily feelings. Section 15. The fact that are bearing on question whether an act is accidental or intentional. Section 16. Existence of business when relevant, of course. Existence of business when relevant, of course. Section 17. Definition of admissions. Definition of admission. What is admission? Just, you must find out the definition in the section 17. Section 18. Admission by the party or admission by his agent. Section 19. Admission by the person whose position must be proved as against the party to shoot. Section 20. Admission by the person expressly referred to by the party to shoot. Section 21. Proof of admission against the person who are making them and by or on their behalf. Section 22. When all admission as to the content of documents are relevant. This is the proper pronunciation of British slang, and the American pronunciation is relevant and relevant. Just you have to choose one of the two. Otherwise, without these two, if you pronounce it in other way, you must be wrong. Okay, thank you very much. Come to the point. Section 23. Admissions in civil cases when relevant. Section 24. Come to the point of confession. Confession caused by inducement, threat or promise. When relevant in criminal proceeding. You have to understand the matter, understand the point in criminal proceeding. Confession caused by inducement, threat or promise when relevant. Section 25. Confession to the police officer cannot be proved. Confession to the police officer cannot be proved. Section 26. Section 26 discuss about the point confession by the accused while in custody of police cannot be proved against him, cannot be proved against the accused. Section 27. How much of information is from an accused will be proved. Section 28 discuss about the matter confession that has been made after removal of impression caused by inducement, threat, or promise is relevant. Section 29. Confession that is otherwise relevant cannot be taken as irrelevant because of promise of secrecy. Section 30 discuss about the matter consideration of proved confession that is affecting the person who is making it, and others shall be jointly under trial for the same offense. I think section 30 tells about the jointly trial. You have to remember the point, jointly trial for the same offense. Section 31 discuss about the matter. The matter is that admission that are not conclusive proof but may stop. You have to remember the point, conclusive proof. Now we discuss about the flowing section. The flowing section in title is that the statement that are given by the person who cannot be called as witness. Okay, come to the point. Section 32, the section discuss about the matter. The matter is the cases in which the statement of relevant fact by the person who is dead and cannot be found, etc. is relevant. Section 33 tells about the relevancy of certain evidence for proving the truth of facts therein is stated in subsequent proceeding. And we now discuss about some section, flowing section, that their title is statement that are made by the persons under special circumstances. 34. Entries in books of accounts when relevant. Section 35. Relevancy of entry in public records that is made for performance of duty. Section 36 discuss about the matter and the matter is relevancy of statements in maps, chart, or plans. Section 37 relevance of statement as to the fact of public nature. Section 38 relevancy of statement as to any law contained in law books. Section 39 discuss about the title matter, how much of statements is to be proved. Okay, come to the point. Section 39 discuss about the matter. The matter is what evidence shall be given when a statement forms a part of a conversation, document, book, or series of letters or papers. Okay, now we discuss about the following section and the title of the following section, or the summary of the following section, or the PC of the following section is judgment of course of justice when relevant. Judgment. You have to remember the point. The following section discuss the matter judgment. In every section, you just add the title judgment. Okay, come to the point. The section 40, the section 40 discuss about the matter. Previous judgment are relevant to bar a second suit or a second trial. Section 41, relevancy of certain judgment in probate jurisdiction. Section 32, section 32 discuss about the matter, relevancy and effect of judgment, orders or decree other than those that are mentioned in the section 41. Section 43, judgment, TDC, other than those that are mentioned in the section 42 when relevant. Section 44. Section 44 discusses of the matter. The matter is fraud or collision in obtaining judgment or incompetency of court may be proved. Now we discuss about some section. The title of this section: opinion of third person when relevant. Of course, my dear guys, just you have to remember the point. The point is that opinion. You have to remember the title, point, opinion. And now come to the section number 45. Section number 45, opinions of experts. Section number 46, fact bearing upon opinion of expert. Section 47, open as to handwriting when relevant. Opinion as to the handwriting when relevant. Section 48. Section 48 discuss about the matter. The matter is that opinion as to the existence of right or custom when relevant. Section 49. Section 49 discuss about the matter. The matter is opinion as to use tenant. It is when relevant. Section 50. Section 50 discuss the matter. The matter is that opinion on relationship when relevant. Section 51. Section 51 discuss about the matter. The matter is grounds of opinion when relevant. Now we come to the another title. The title is character when relevant. You have to remember that. My honorable guys, you have to remember the point. Just to set the flowing section, just to discuss the matter character. You have to remember that point. The point is character. Okay, come to the point 52. Section 52 discuss about the matter. The matter is in civil cases character to prove conduct imprudent is relevant. Section 53 discuss about the matter in criminal cases. Previous good character is relevant. Previous good character. You have to remember that point. Previous good character. And section number 53. Section number 53 discuss about the matter. Not 53. 54. Section 54 discuss about the matter. Previous bad character. I mean irrelevant or not relevant, except in reply. Section 55. Character that is affecting the damages. You have to remember the point. Affecting the damages. Character that is affecting the damages. Okay, my dear honorable guys, I just finished reading the point. The point is relevancy of fact that is of 55 to 55 section. Now we come to the another part 2. Part 2 discusses discuss the section 44 section in total. Okay, now come to the point. I want to discuss the section one after another. Section 56. Section 56 discuss the matter fact that are judicially noticeable. Need not be proved. Section 57, fact of which the court must take judicial notice. The court must take judicial notice. Section 58. Section 58 discuss the matter. The matter is fact that are admitted, need not be proved. Section 59. Section 59 discuss about the matter, oral evidence. Okay, come to the point. 59 discuss about the matter. The matter is that proof of facts by oral evidence. You have to remember that what to mean by oral evidence. Oral evidence, and then just and come to the section number 60. Section number 60 is of the matter. The matter is that all evidence must be direct, must be direct, not indirect. All evidence must be direct. And now we discuss about the title. Title is documentary evidence, and documentary evidence is discussed by some section as a section that are 61. Section 61 discuss about the matter, proof of contents of document. Contents of document. Section 62, primary evidence. Primary evidence. Section 63, secondary evidence. Secondary evidence has been discussed by the section 63. Section 64. Section 64 discuss the matter. Matter is proof of document by primary evidence. Section 65. Section 65 discuss about the matter. Discuss about the matter that cases in which secondary evidence that is relating to documents may be given. Section 66 rules to the notice to product documents or documents. Section 67. Section 67 discuss the matter. Matter is proof of signature and handwriting of a person that is alleged to have signed or written the documents produced. Section 68. Section 68 discuss about the matter. The matter is that proof of execution of documents required by law to be attested. Required by law to be attested. You have to remember the point to be attested. Section 69. Section 69 is of the function, is of the title, that is proof where no attesting witness found. Section 70. Section 70 has been discussed by the matter. Matter is the admission of execution by the party to attested document. Section 71. Proof when attesting witness denies the execution. Denies the execution. Section 52. Proof of documents that is required by law to be attested. To be attested. Section 73. Comparison of signature, writing or seal which other admitted or proved. Section 73. Comparison of signature, writing or seal which other have been committed. Which other person, which other law have been, which other judges have been admitted or proved. Now we discuss about the title public documents. In the following section, public documents have been discussed. Section 74, public documents. You have to remember the point, public documents. Section 75, private documents. private documents. Section 76. Section 76 discuss about the matter. The matter is certified copies of public documents. Section 77. Section 77 proof of documents by producting of certified copies. Section 78. Section 78 discuss about the matter proof of other official documents. Now I discuss about the title. Title is presumption as to documents. In the following section presumption as to documents is discussed or are discussed by the following section. Section 79 discuss about the matter. The matter is presumption as to the genuineness of certified copies. Section 80 presumption as to the documents produced as the record of evidence. This title is discussed by the section 79. Section this is not discussed by the section 79. This has been discussed by the section 80. Section 81 is omitted, and section 82 presumption as to the document that is admissible in England without proof of seal or signature. Section 83 presumption as to the maps or plans made by the authority of the government. Section 84 presumption as to the collection of laws and report of decision. Section 85 discuss about the matter. The matter is presumption as to the powers of attorney. Section 86 presumption as to the certified copies of foreign judicial records. Section 87 discuss the matter. The matter is presumption as to the books, maps and chart. Section 88 presumption as to the telegraphic message. Section 89 presumption as to the due execution etc. of the documents that are not produced. Section 90 discusses about the matter presumption as to the documents of 30 years old. Now we discuss about a title. The title is the exclusion of oral evidence by the documentary evidence. Okay, come to the point. Section 91 evidence of term of contract, grants and other disposition of property reduced to form of documents. Section 92 inclusion of evidence of oral agreement. Section 93 exclusion of evidence to explain or to amend ambiguous documents. Section 94 exclusion of evidence against application of a document to existing facts. Section 95 evidence to the document that is unmeaning in reference to the existing facts. Section 95 discuss about the matter. The matter is Section 96 discuss about the matter. The matter is evidence to the application of language. application of language, which can apply to one only of several persons. Section 97. Section 97 discuss about the matter. The matter is the evidence as to application of language to one of the two set of facts, to neither of which the whole correctly applies. Section 98. Evidence as to the meaning of eligible character etc. are relevant. Section 99. Who may give evidence of agreement bearing term of document. Section 100. Saving of Provision of Succession Act, that is relating to will. Now we discuss part 3. In part 3, there are so many titles that have been discussed by the part 3. Now I want to discuss the section one by one. Section 101, burden of proof. Burden of proof. Section 102, on hope, burden of proof lies. Section 103, burden of proof is as to a particular fact. Section 104, burden of proving a fact to make evidence admissible, or in other way, burden of proof that makes the evidence admissible is a fact to be proved. Section 105, burden of proving the accused case that comes within exception. Section 106, burden of proving a fact that is especially within the knowledge of anybody, knowledge of the accused. Section 107, burden of proving death of a person who is known to have been alive within 30 years. Section 108, burden of proving a person is alive who is not been heard of for 7 years. Section 109, burden of proving is as to the relationship in the case of partners, landlord and tenant, principal and agent. Section 110. Section 110 discuss about the matter. Burden of proof is as to the ownership. You have to remember the point. Section 110 discuss about the matter. The matter is ownership. Burden of proof is as to the ownership. Section 111, proof of a good faith in transaction. One part is in relation of active confidence. Section 112, birth of a child during marriage is a conclusive proof of legitimacy. Section 113 is omitted by Bangladesh laws. Section 114, the court may presume existence of certain facts. Now we come to the point. The point is estoppel. In the following 3 sections, estoppel is discussed. Section number 150 discuss about estoppel. Section 116 discusses the matter. Matter is that estoppel of tenants and estoppel of license of a person in possession. Section 117, estoppel of the acceptor of bill of exchange, value or licensee. Okay, now come to the point. The point is witnesses. Point is of witnesses. There are some following section in the following section, witnesses is discussed. Section 118, who may testify, who may examine. Section 190, dumb witnesses. Section 120, parties of the civil suit and their wives and their husbands. A husband or a wife of a person under criminal trial. Section 121, judges and magistrates. You have to remember that point, judges and magistrates. Section 122, communication during marriage. Section 123, evidence as to the affair of his state. Section 104, official communications. Section 125, information as to the commission of offenses. Occurrence of offenses. Section 26, professional communication. Section 27, Section 126, to apply to interpreters, etc. Section 28, privilege is not waived by the volunteering evidence. Section 28 is discussed by the matter. The matter is that privilege is not waived by the volunteering evidence. Section 29, confidential communication with the legal advisor. Section 130, production of title deed of witness who is not a party. Section 131, production of documents which another person having possession could refuse to produce. Section 132, a witness is not excused from answering on the grounds of that answering criminality. Section 30 discusses about the matter. The matter is that section not 30. Section 33. Section 33 discuss about the matter. The matter is an accused. Section 32, number of witnesses. And now the following title will be discussed by the following section. The section are that section number 35, order of production and order of examination of witnesses, and section 136 tells about the matter. The matter is judge is reliable as to admissibility of evidence. Admissibility or admissibility, whatever you pronounce it is right, is correct. Section 37, examination in chief, examination in cross-examination, re-examination, and subscriber matter have been discussed in the section 137. 138, order of examination. This is important section. Order of examination. Section 39 discusses about the matter. The matter is cross-examination of a person who has not been called to produce a document. Who has not, this is not correct. Who has been called to produce the document. Who has been called. Section 140, witnesses are as to character. witnesses are as to the character. Section 41, leading question. This is an important section, leading question. And section 42, when leading question must not be asked. And section 43, when leading question must be asked. Section 44, evidence as to the matter in writing. Section 45, cross-examination is as to the previous statements in writing. Section 146, section 146, questions that are lawful in cross-examination. That are lawful in cross-examination. In cross-examination, you have to remember this point, my dear honorable guys. In written in cross-examination. Section 147, section 147 discuss about the matter. The matter is that when a witness must be compelled to answer. Section 48, the court may decide when the question shall be asked and when the witness shall be compelled to answer. The witness shall be compelled to answer. Section 149, the question that are not be asked without reasonable grounds. The question that are not be asked without reasonable grounds. Section 50, 150, procedure of the court. In case of any question be asked without reasonable grounds. Section 151, indecent and scandalous question, or in other way, indecent and scandalous question or questions. Section 152, question intended to insult or annoy. Section 153, exclusion of evidence. To a contradictory answer to the question of testing veracity. Section 154. Section 154 is very important for everybody. Section 144 discuss about the matter. The matter is that, and that is adverse witnesses. In other way, question by the party to his own witness. Section 155, impeaching the credit of witness, or in other way, impeachment as to the credit of witness. Section 156, the question that are tending to corroborate evidence of relevant fact and result. Section 157, former statement of witness may be proved to corroborate a later testimony as to the same fact. Section 58, what matters may be proved in connection with proved statement are relevant under section 32 or 33. Section 59, section 59 tells about the matter. The matter is refreshing memory. Section 160, section 160 discuss about the matter. The matter is that testimony to the fact stated in the document mentioned in the section 159. Section 161, right of adverse party as to the writing used to refresh memory. A right of adverse party You have to remember this point. Right of adverse party. Section 62. Production of document. Production of document. Production of document. Okay, section 163. Giving as evidence of document. Call for and produce no notice. On notice. No notice is not correct. On notice. Produced unnoticed. 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 Section 164. Using as the evidence of a document. Production of which was refused unnoticed. Refused unnoticed. Or in spite of noticed. Section 165. Section 165 discuss about the matter. The matter is that judge power to put question or to take order or production of any type of document. Section 166. Power of jury or power of assessor to put question, to put questions. Section 167. Section 167 is discussed by the chapter 11, and the chapter 11 in discussed by the only one section that is 167, and the title of 167 is improper admissions and rejection of evidence. This is the title of this section, and the summary of this section, section 167 is no new trial is for improper admission or rejection of